versus State of Mysore in the mid-60s to the 7-judge bench in mid-70s in N.M. Thomas versus State of Kerala is a recognition that even in equality of opportunity, you may have to have differential treatment or what we call proportional equality in order that there be a level playing field. Okay, so that if you say that everybody in order to enter my constitutional law class must jump over a 10-foot wall, if I were to make such an absurd rule like that, then obviously people who are taller will find it easier to jump across. So if I wanted to have equality of opportunity and I've made a rule saying everybody must jump over a 10-foot wall, then in order to have equality of opportunity, I must make special provisions right there. I must have steps for those who are shorter and who cannot jump over that 10-foot wall. So embedded in equality of opportunity itself is not just formal equality of treating everybody equally, but also an element of what I call substantive equality yesterday. Substantive equality meaning that you need to do some little tweaking at the beginning itself in order that you can allow people to participate, or what is known as to create a level playing field. So, this much of a background I think is sufficient for me. My voice is breaking, is it? What shall I do? My voice is breaking. Okay, is it better now?
No, ma'am, it's not breaking. Might be the problem from the other side.
Okay. I'll just try to be louder. I'll just be louder. I'll be louder. Okay. Now let's look at Article 14. Okay. By the way, now of course DU's LLM program has changed because UGC with its idea that every LLM must be uniform has laid down all compulsory papers and all. Till about 5 years ago, when life was different, we used to have our own papers. For a very long time, I used to teach an entire semester just on 14 and 19. Okay, it was called Civil Liberties. There's that much to teach. You can just teach equality. I could happily teach equality for a whole semester. There's that much material. Now, what can one do? We are, of course, having to squeeze everything into this semester. So, I'm saying all this just to point out to you that everything I'm telling you may not be necessary from an exam point of view. Okay, but I think since my classes are an occasion for many of you who are interested to read further, I'm going beyond. I'm not just doing one Dukhi level teaching, so that if you wish, you can learn more. Okay. But before the exam, just follow our case material and the syllabus there. That should be enough. Now look at Article 14. It says equality before law. That's the marginal note. And then it goes on to say the state. So it's one of those state-centric provisions. It does not have horizontal effects. Okay. And so it's a vertical provision. I've explained this further, so I cannot keep going on again. Okay? The state shall not deny to any person equality before the law. That's the first limb. And the second is, or the equal protection of the laws within the territory of India. Now look at it closely as a text. It says the state. So we know we're talking about the state and the state alone. So if a father said that I'm going to treat the son better क्योंकि वो मेरे बुढ़ापे के लाठी है, and my daughter is पराया धन, and had such a notion like that, इसलिए मैं उसको बस स्कूल के बाद शादी करा दूंगा. There's nothing you can do in terms of Article 14, because 14 and that equality is only talking about the state, and our understanding of state from Article 12 quite clearly says that an individual private person is not fulfilling our tests of state, because there's no deep and pervasive power, there's no financial, managerial, all those other questions that we've looked at. The state shall not deny to any person. So it uses the word person, it doesn't use the word citizen. So therefore, unlike Article 19, 14 has a far broader scope because 19 is confined to citizen. Now, who is a person? Person is not defined, but if you look at it, Salmond in his book on jurisprudence says a person is any person who is capable of rights and duties. So you need to have the capacity to be a holder of rights or to bear certain duties. Only then can you be a person. Now, if you take this kind of opinion of a person, it will come as no surprise to you that the Mitakshara or the uncodified Hindu law refused to treat persons with disability as persons. It refused to treat anybody who was disabled, blind, visually handicapped, etc., as a person. And as a result, if you look at ancient Hindu law, such a person could not be a koparsna. Okay, and this is the way it used to be, because that person really, the definition that had impliedly been followed, say in uncodified Hindu law, was such a person is incapable of rights and duties. We may completely disagree with it because I think thinking has changed so much in today's time. Okay, but we can also understand where that idea came from, that because you are quote unquote lesser than another person, you don't have the capacity to hold property or to enter into marriage, so on and so forth. Okay, I'm not condoning it, but I'm saying that being enough of law students, we can understand this. Okay, now so who is a person? Somebody who has a capacity to have rights and duties, and that person need not be only a natural person, it can also be a artificial person. So I turn your attention now to Articles 292 and 293. These are very interesting parts of the Constitution that we don't teach. Simply, it's just an overload really for LLB students. But fiscal federalism is a terribly, terribly interesting area of constitutional law. And if any of you ever decide to go on to practicing, and I think taxation law is really a good branch of law, you will realize. Look at 292, borrowing by the government of India. So the executive power of the union extends to borrowing. 293, borrowing by the states. And then you look at Article as an entity, government of India borrows. As an executive entity, the state borrows. So it is borrowing, it is having a right to borrow, it will have a debt to the Consolidated Fund of India. In one sense, it is acting as a person, as a collective entity. It's artificial, of course, but it does. And you can see in Article 300. So look at Article 300, and it tells you that the government of India may sue or be sued in the name of Union of India, and the state can sue and be sued. So an artificial personality has been created under Article 300. And as a result of that, under Article 292 and 293, they can borrow, that is, they can enter into debt, they can have the right to claim from the Consolidated Fund of India. And then, very interestingly, Article 294, the government of India is the successor to all the property, assets, rights, liabilities, and obligations of the erstwhile government of India, which was under colonial rule. So there is a straight line of succession which this government of India created by the Constitution to succeed to the rights and liabilities of the past. Now, this 294 is yet another example of colonial continuity. Do you remember we looked at Article 13.1 and I used this expression of colonial continuity, that legally the laws have colonial continuity. But 294 gives us a colonial continuity in terms of the personality, the artificial person of the government of India, steps seamlessly into the shoes of the British colonial India. Okay, and 294 is our case in point. So it's like it's a class 1 heir, it's the number 1 heir. All the property and assets which were vested in His Majesty for the purposes of the government and dominion of India. The government of the dominion of India. Remember that between 1947 till 1950 we were a dominion, and then we become a full-fledged republic. Okay. And then look at 295, succession to property, assets, rights, and liabilities in other cases. So this is talking about Indian states which were part B of the first schedule. Those were not British India states but were the Indian princely states, as well as, so it just explains that part B and part C. So those of you who are in administrative law now, you know the In Re Delhi Laws Act, which I think perhaps may be the first case that you're studying after Rex versus Bureau in administrative law, which is also, you know, a lovely paper. For many years, I used to teach administrative law also in this faculty, but then you cannot teach everything. But administrative law is a great paper too, and you know, in Re Delhi Laws Act explains to you the classification of Part A, Part B, Part C states. So I don't need to waste my time. Now, 296 is a very important article which we happened to look last semester when we were doing West of Bengal versus Union of India. This introduces the private law notion of bona vacantia, and it introduces the notion of escheat. Now, escheat is a principle you have already studied when you were doing which branch of law? Which branch of law? Escheat. Hindu law, that's right. That is when there is no available class 1 heir, then property has to go to the state. And this is a principle because once a property has been declared to be private property, it, you know, like we say, nature abhors a vacuum. Private law abhors an absence of a legal owner. So once property becomes private, it immediately lapses to the state. So escheat is where previously there had been a private owner, but now with the absence of a class 1, class 2, class 3, class 4 heir, I'm taking the case of Hindu law, or if you take Sunni Hanafi law, then any of the, you know, categories of heirs that are there, in the absence of any of them, it will lapse to the state. Bona vacantia is something quite different, and which we had studied also when we did State of West Bengal. Property over which there has never been a private owner. It's vacant land. Bona vacantia. It's, you know, in a bona fide manner, it is vacant land which has never had an owner. Such land will also. So look at 296, look at the marginal note. Property accruing by escheat or lapse or as bona vacantia will always belong to the state. When did we study this? We studied this when we were studying Article 1. What is the ways in which the government of India can acquire property? So if, for example, an earthquake throws up an island in our territorial waters, that will be bona vacantia, which will lapse to the government of India. It's new property that's been created, or the lapsing, etc. So all these are 297 extends the same notion to the continental shelf, exclusive economic zone, and territorial waters. So the general international law principle that we have rights over territorial waters and economic rights over the economic zone and the continental shelf, that principle which comes to us as a principle of international law through the principle of pacta sunt servanda in international law, in municipal law takes the place of Article 297, where there is an assertion by the Indian state that this land is ours. And in 299, you have contracts. Now, all these articles from 299, 292 to 299 it would not be possible for the government of India to act as a person, to enter into contracts, to enter into debts, to acquire and hold property if it did not partake of the quality of being a artificial person. So therefore, Article 14. Now, does that mean that the state should not discriminate against itself? That the union should not discriminate against the states? Is it possible for a state to come under Article 131 of the Supreme Court and file a suit, which you know is the only way in which a case can be filed by the state against the union or a state against another state by alleging violation of Article 14? Yes, it can. It can. It can say that there has been stepmotherly treatment, and the word person can be extended to Article 14. So if you look, for instance, at the the well-known cases, State of West Bengal versus Union of India, which you studied last year, it was alleging that its rights have been infringed, and it was a suit under Article 14. Okay. And technically speaking, Article 14 can be cited. Usually they do not cite it, but as a lawyer, as a possibility, it can be. Now I'll come back to 14 once again. The state shall not deny to any person, and we've seen it includes everything. It can even include animals. The interesting question is that the animal, of course, cannot file the suit and a petition under 32. So then what do? You can find somebody else to file a PIL for you. Okay. Ma'am, can a PIL be filed? A PIL, but then by a next friend with a locus standi. Yeah. Right. So it can be done. So if you look at the Jallikattu case, there has never been a case, a PIL has been filed asking for stoppage of Jallikattu. But they have never ever filed on behalf of that bull that is about to be killed. Never. But technically it can be done. Okay. The state shall not deny to any person equality before the law. So you cannot provide for equality before the law. So this has a principle of the rule of law that everybody must be treated equally before the law. Okay, so this principle that you must be treated equally before the law. So many times people say that this first limb incorporates the rule of law principle. And then the second part of 14, or the equal protection of the laws. Now look at this, the law and the laws. Okay, what do you think is the difference here? Before the laws, before equality before the law, and equal protection of the laws. So, based on your knowledge of English language, what do you think it means? Ma'am, the law may be referred to the Constitution of India, which is the supreme law of land, and the laws, the other statutory provisions that are. Well, not quite. Does anybody else have another view?
Equality before the law means if a law is governing a particular, it's talking about a single law. When a law is governing some people, category of people, then all people should be treated equally before that particular law. And equal protection of laws means there are multiple laws, and the bit relates to multiple law. And the law means a single law which is governing at the same point of time. So many words.
Okay, anybody else? One more person.
Ma'am? Law refers to the rule of law, and laws refers to various legislation and modification.
Okay, yeah, I think I would agree. But there was another voice that had wanted to speak. Ma'am? Yes, please.
Ma'am, equality before the law means that all the people will be treated equally. And equal protection of the laws means that if those people don't stand on equal pedestal, then different provisions can be made for them.
Okay. Now, of course, many people have commented on this, but I think what I would perhaps like to just focus on, and I'll get some more occasions to explain this a little more. Equality before the law meaning law in its compound sense. We're talking about the entire law. Okay, so it would include constitution, it would include all the legislation, the entire body of the law. We're using it in a collective sense. So when we're using the word the law, we will be referring to the definition that we are going to be using under Article 3A, that the law includes everything, legislation, bylaw, everything, the whole body, including the constitution itself. Okay? And then equal protection of the laws. There we're using the law in its individual sense, that the laws, that is the IPC, the CRPC, as in that individual sense. Now, some people have tried to explain that, this is in its negative sense, and this is the latter part is in the positive sense. Some commentators have made that point. You shall not deny, and that there is the equal protection, and this is the positive part. But there have also been judgments that have explained that they are just two sides of the same coin. Personally speaking, I don't think it's worth too much time to try and split hairs and find out if there's a difference between denying equality of the law. So that broader principle, of course, incorporates the rule of law principle, that nobody should be discriminated against. That is also included in the Article 14, and that you are equally protected by the law. That is, the law should be was there must apply equally to, and you will see embedded in it the principle of rule of law, that everybody is bound by the law. There's nobody, that the law is no respecter of persons, be you ever so high that the law is above you, as I mentioned yesterday, which is like one of those well-known phrases people use about the rule of law, as well as it also incorporates the principle of non-discrimination within it. So the structure of 14 to 18, when you look, there is a gradual detailing, there's a gradual concretization as we move between 14, 15 and 16. So they are all seen as part of one whole, 17 and 18 also. That is, 14 is the broad general principle. A little more detailing is there in 15, dealing with how people should not be discriminated. And then 16 is, of course, the most concrete of them all, which is dealing only with employment. Okay. But if you're looking at a sphere like education, then your go-to article will be Article 15. And 14, of course, is the broad principle itself. So we will be spending time both looking at 14 and 15, and then, of course, Article 16. Now, when you say that nobody should be denied equality of the laws, okay, then what it means is that equals should be treated equally. Would it not be unequal to treat people who are unequally situated the same way? And therefore, within Article 14, apart from rule of law and non-discrimination principles which are hidden in 14, also is hidden another feature which the courts have called as the classification. That is, Article 14, in order for having equal treatment, requires that we must treat equals equally and unequals must be differently treated. Now, treatment of unequals differently being part of the notion of Article 14 itself immediately alerts you to the principle that proportional equality is not against the principle of equality. If equality requires that people similarly situated must be treated equally, it also is implied that people who are not similarly situated, who are differently situated, must be treated differently. And treating people differently is nothing other than having a basis or justification for differential treatment, or what we had called earlier proportional equality. And one of the finest theoretical justifications has been put forward by John Rawls. Now, John Rawls is a philosopher who wrote a very famous book initially called A Theory of Justice. And then, of course, he went on to write a couple of more very important books that sort of elaborates. When he wrote Theory of Justice, he put forward a theory of justice, and you will see in it, embedded in that theory of justice, is also a principle of equality and a principle of treating different people differently, and that he called as his difference principle. So his he had two broad principles. If you're able to follow, please do, but I don't want to spend more time. But those of you who studied political science will quickly understand what I'm trying to say. His principle of justice was that, to treat people justly or to treat them fairly, you need to ask whether that treatment fulfills his two texts, his broad two principles. And his first principle is that every person should have an equal right to the most extensive basic liberties which is enjoyed and which is compatible with similar equal liberties enjoyed by everybody else. So let me repeat that again. That is, his first principle was, to be a just society, every person must have such basic liberties as can be given to everybody else. It cannot be that some people have more liberty and some people have less. So everybody, you must have such amount of basic liberties as is compatible with everybody else having similar basic liberties. Now that we have discussed our principles of equality, you will notice that this first principle of justice has embedded in it a principle of numerical equality, that everybody will have the same thing. Everybody will have universal adult franchise. We're not going to ask stupid questions like, अरे उसको क्या वोट देना, उसको कुछ नहीं पता. No paternalism, please. Let everybody have the right to vote. Don't think that just because you read the newspaper, you're somehow a better voter than somebody who doesn't. No. Numerical equality. You see that embedded in the Rawlsian first principle, that everybody has an equal right to basic liberties, coextensive with the basic liberties, or coextensive and compatible with similar basic liberties available to all. And the second principle, which has a couple of parts, but one of them is known as the difference principle, is that economic and social inequalities is permissible provided that these are reasonably arranged and they are arranged to everybody's advantage. That is, even if some people are a little richer, this is for the benefit of everybody else. So some amount of inequality is permissible provided it's for people's benefit. So one of the examples, for example, that John Rawls gives in his book is somebody who studies a long time to become a doctor or a surgeon, then it's okay, it's just, it's fair if that person gets a higher salary or earns more than other people, because eventually it is to the advantage of everybody else, because that learning is going to be used by all of us. So it is in society's interest that there are some people who just shut themselves up in a room. You know how hard doctors study. Do lawyers study that hard? Do law students study as hard as medical students?
Yes,
more than that.
No, you don't. Come on. Be honest. Be honest.
More than
Be
that.
honest. Which law student ever studied as much as a medical student? Tell me.
Yes, ma'am. All of us, ma'am.
Huh? Do you agree with me that the students in medical school study much more than us?
I'm not private medical.
But we
study as much as them, ma'am, more so.
No, you don't, Ankita. Much as I would like to agree, no, you don't. Those poor medical students sit and mug up books like this fat, and they're forever, ever studying.
Ma'am, don't we go through all these cases and take out the ratios and the stare aside?
You don't study for 8 hours a day.
Ask for a lawyer, ma'am, in our internship days.
Okay, as when you are a junior to a lawyer, yes, but as a law student, you don't. अरे यहाँ पे I've also taught in this faculty 30 years, okay? And they बहुत pride से बोलेंगे बस एक दिन पहले डुबकी लिया और पढ़ लिया और मेरे को 60 मिल गया, okay? They'll come and tell the teacher.
We find such medical students also.
Okay, anyway, maybe you all study. Let me allow you all to have the last word. So maybe you all study very well. So I'm glad for it. So that social and economic inequalities are permissible provided they are for the advantage of all. So that is some amount of inequality is permissible, and those jobs which permit those, and a second part of the second principle is, of the difference principle is, that those jobs or those opportunities, for example, eventually, I think, okay, though they don't study that much, though I conceded that point to you, you will concede this point back to me, that if you look at the top earning legal profession, I think it's in law that they earn more than they learn as doctors. Ye manoge na?
I agree. Yes.
Okay. So those positions which are, giving that greater socio-economic status or earning, etc. Okay. And create that socio-economic inequalities should be available, open to all. There must be equality of opportunity there so that everybody has a go at it. This was his broad